Hey, Kansas City, this is Amy, the attorney, and I am here at the Red Bridge Library. The library is one of my favorite places on earth. I don't go to the Red Bridge Library as much as I used to go to the downtown library when I worked downtown, but I love the library. I love the way it represents the best of what government can do and what a city can do and a community can do. And the Red Bridge Library here was just redone in the last, I'd say, 3 years, and it's gorgeous and very lit and just has many beautiful things. Today, I reserved a room to do an estate planning seminar. So far, we don't have any takers. It's supposed to start at 7, but I figured I would just go live and do the estate planning seminar live on YouTube. And I'm going to start that at 7. So I'm just going to wait until 7 to start. But if anybody has any questions, they can put it in the chat. But basically, I want to talk about estate planning and how it can benefit you and, most importantly, your family, because your family will know what you want to see happen if you get disabled and when you die. And one of those two things, if not both of those things, are going to happen. And I know it's like a little morbid and a little it's hard to think about. I get that. But I do think that you are giving just a tremendous gift to your loved ones by taking the estate planning and getting that done. Of course, there's, lots of lawyers that do it. I'm sort of new to the field. I've been doing estate planning for, I would say, about 6 months. I started in earnest at the beginning of this year. And it is just this wide breadth of information. It's just crazy how much information there is about estate planning. And I'm finally feeling like I have a very good grasp on basically who my target market is. My target market are people like me that own a home, that have saved for retirement, and have adult children, and basically want to make sure that if when I die, that everything goes to my husband or goes to my children, depending if he's still alive or not. But more importantly, part of estate planning is not about when you die, but it's when you're living and unable to speak for yourself. And there's just so many situations where this could happen. And we take care of that in estate planning by powers of attorney, both financial and health. And so I'm going to be talking about that. We're also going to be talking about a living will, another important piece of estate planning, and just such a beneficial thing to have done and discussed with your loved ones. Because if the situation comes up that you can't speak for yourself, oh my gosh, I had Thai food today. Please, pardon me. But if you have the situation come up where you cannot speak for yourself, you want to have empowered somebody that you love to speak on your behalf, and someone that cares about you to be able to take care of your bills and take care of any finances that need to be done. It's just a lot. And you can take that burden away from your loved ones by doing your estate planning. They don't have to guess. They don't have to say, oh, well, what would Jane do in that situation? What would John do in that situation? Because Jane and John have done the estate planning, executed the documents, and talked to you about what they want to see happen. And I'll talk about it in my seminar that's going to start in about 8 minutes, but I have personal experience with this. And in terms of having documents and needing documents, but just knowing that what to do in that situation. The other reason you want to do it is, why take the risk of people fighting after you pass away about your earnings. And it's not like, if I passed away, my husband passed away right now, that, my kids could retire or anything. But I have worked, and you have probably worked and have money in retirement, and, going to try and eke that out and live on that when we retire. But if there's leftovers, I want my kids to have it. And, I've always felt like $20,000 is a meaningful piece of money, a meaningful gift. I mean, everything is meaningful, but that's a life-changing gift. That's a down payment. That's a year at Mizzou or a year at KU. And I do think that that is worth protecting and directing where you want to do that and how it's done. And if you don't do it, then it's up for somebody else to decide, a judge or the government, and you don't want that. Now, now how a judge or how a court would decide that might be in line with what you want. Split it three ways. In my case, I have three kids, but it might not be. And this is in our time, in our situation, where there's not necessarily, the prototypical family of your mom, dad, kids. So many more blended families: mom, dad, kids, stepkids, half brothers. But not only that, but the situations where your friend group is your family, and you have met your people maybe outside of your family. Maybe it's a situation where you are retired and you have somebody that you want to be able to receive what you have worked for. And for sure, a judge is not going to decide it that way. For sure. Like there is a intestate succession plan, and we'll go over that during the seminar. But so that would be important. And I think another misconception with estate planning is that only rich people need to do that. And I just don't believe that at all. And if you have a home and you have retirement accounts, you have got to get your estate planning in order so that things can pass along to the people you love. We will get to that. So I'm just going to wait. And I know it's kind of weird, dead air for 5 minutes. I am going to close the door to the library. If you're in the Red Bridge area, if you're out here in South Kansas City, I would love to see you. I could talk to you in person. I am doing these estate planning workshops the third Wednesday of every month at 7 p.m. So if you're seeing this and thinking, I really want to talk to her, come to one of my estate planning seminars. The last one I had, only one person showed up, and she basically got everything I knew, got all her questions answered, and this would be the time. So I am glad you're here. Thank you for watching, and we're just going to pause a little bit and wait for 7 o'clock to roll around, see if I get any takers here. Like I said, I'm going to close the door. I'm so glad you're watching this video. I'm so grateful. I know that I can help you. If you are in Kansas City, Missouri, or Kansas, I'm licensed in both, and we will talk soon. One. Okay, I think I put on a little bit of In the Heights, one of my favorite musicals. Hopefully, you got to hear a little bit of that from the movie In the Heights. It is 7 p.m., so I am going to start talking about estate planning. And this is very similar to if we met in person, what I would be talking about with you in estate planning. So now I will see, there might be somebody coming in, but probably not. But I'm so glad to be doing it here. The more I practice, the better I become at it and presenting it. And like I said, I really do want to help people in this realm. I know everybody needs it. So I'm first going to talk about, let me pull up my slides. I'm going to give you a couple different family situations. And so the first one is the Jones family. They're a blended family. And Bob Jones and Casey Jones are the mom and dad. And Bob has 3 children from a previous marriage. Casey has 1 child of her own. And all of them are over 18. So they married later after the kids were all grown. And the one bugaboo that we will talk about is that Bob's oldest child, Sarah, has faced some challenges and her relationship with drugs, and that has made her unreliable. And so Bob and Sarah, or Bob and Casey, when they're starting to do estate planning, they're thinking about, what would happen if we passed away and Sarah did come into, I was saying $25,000 earlier as a possible amount that she would receive. But what if Sarah were to come into $100,000? What would that mean for her life? And fears about how she would do with that money. And so we'll talk about that. And then I'm going to talk about the Smith family. And this is a traditional old school family, Emily and Tyrone Smith, and their 2 young children, happy family, raising their kids, having their careers. And they did not do their estate planning. And so that is something we're going to talk about of what would happen. Now, there are many reasons why people do estate planning. And I think the number one reason is that people have had a negative experience of people that don't have their estate planning done. So they have seen firsthand, oh my God, I should get this done because this is a nightmare for me. And one of my clients who, she was well into her 50s. Her father, who was 25 years older than she was, he passed away, twice divorced, was living with his girlfriend. And when he was married to his second wife, they had, my friend was very aware of all of the situation in terms of, like, he was very clear, here's my estate planning binder, this is what I want to see happen. He gets divorced from wife number 2, living with the girlfriend, and big life event, didn't change any estate planning. They didn't have access to those documents, and he had made a handwritten will saying that he wanted the house that he was sharing with his girlfriend to go to his girlfriend. And that was not, my friend's understanding of what would happen. And they had to pay so much money to a lawyer to get everything straightened out. And also, they didn't have to, but they did negotiate with the girlfriend. She doesn't have a claim. She does not have a claim. And, but they, of course, this was somebody that spent their last days, they're with their dad, and they recognize that. And so they ended up negotiating a settlement. But that's after many paid hours of lawyers, total heartache. In the dad's final months and weeks, sort of not knowing about how he wanted to be cared for. So, but that's the number one reason people come to me is they've been through a nightmare situation. They had to go to probate for their parents, or they had a situation where the parents were, where it wasn't clear or there wasn't estate planning. And so it was a mess trying to get all the assets together. And they don't want to see that happen. Another reason people come and do estate planning is because someone in their life has passed away and they see, hey, you know what? I gotta get in this and I gotta do this, whether or not the situation was pleasant with the person passing away or not. Now, a reason you should do estate planning is if you do have a change. So if you are like one of our families here, the Jones family, this blended family, well, they obviously had a trad marriage, and then it went into a blended family, and that's a life change. That means that your estate planning documents should be updated or changed. If you got a new job, if you yourself inherited money, your estate plan should be taken. You should be taking a look at the estate plan. I think, and the big thing, of course, is when you have kids, you want to go and get your estate plan done. And our story was that we were foster parents to our 3 children for 2 years before we were able to adopt them. And we adopted them, had the estate planning attorney appointment that week or very shortly after, because then we were going out of town. And so when a family with young children, the main concern is really like a Titanic type situation. Both parents die. It's really like the obviously terrible situation, but setting up who you want the guardian to be of your kids if that Titanic terrible situation happens. And so many people, when they become parents, also go and get their estate plan done. But I just redid an estate plan for somebody who did that when she had her son. And this is a person that a single mom from the start, had her son, and in her estate planning documents had named her best friend and to be basically the person that would speak for her. She also named her mother. Well, now her mother has passed away and her friend is not in the city anymore and not able to make decisions for her. She doesn't want that anymore. So her estate planning documents were not in date. So we're updating them to what she wants to see happen. And, I'm getting to an age where, not yet, because I still have, my kids seem still young at 21, 19, and 17, but where my kids would be the person that would be the power of attorney for me or for my husband. That's not the situation now, but it is the situation with me and my 83-year-old mother. So let's get into the nitty-gritty of it. When you do estate planning, there's estate planning documents that I would create for you that are used when you're living. And then there are estate planning documents that are used after you pass away. So the first thing we're going to talk about is the estate planning documents that you use that I would create for you, for use in your lifetime. And the big two are the powers of attorney. So there's a power of attorney for healthcare, and there's a power of attorney for finances. And both the Missouri Bar and the Kansas Bar, I believe, provide those on their website. So if you wanted to do it yourself, you can download those from the website and be able to have them. They are such important documents. They give whoever it is that you have decided to give your power of attorney to the power to make medical or financial decisions on your behalf. And so this would be a situation where you are not able to make decisions. You are not able to communicate with the doctor. And so the person named or the people named in your powers of attorney would be able to have those conversations with the doctor or be able to pay bills on your behalf, be able to execute a number of different things financially that might be needed. Woo, it's hot in here. I brought a jacket because I thought it was going to be cold in the library, but it is not. Just like everywhere in Kansas City right now. I mean, it is kind of nuts how hot it is in Kansas City and all over. So anyway, all right. So the powers of attorney. Now, in those documents, my preference is to have one power of attorney, and then you name a secondary and possibly a third that would do it in case your power of attorney was unable to serve. So, stuff happens. You have to plan, when you're doing estate planning, you're just planning for now. And so we may, I'm in my situation, I may entrust that to my husband at this point, but my sister would be the secondary power of attorney. And so if he was passed away, then she would be able to make decisions on my behalf and act on my behalf. The living will is another document that I can create and that is also available. I mean, living wills are useful. And, society as a whole wants you to have a living will so that there's no Terry Schiavo. Oh my gosh, what's the name of the lady? Nancy, somebody here in Missouri in the early 90s. There was sort of this struggle of knowing, she was brain dead, and very similar to Terry Schiavo. And there was a struggle between her family and she, they didn't have the documents. So Nancy Cruzan. Okay, so the living will is a document where basically you are saying to the doctors, what situation would you want to not be given chemotherapy, do not resuscitate? And generally those are situations where you are, the doctors have said to your family, they're not going to recover, or that's basically it. And so then you lay out, and the way I have it is very similar to the Missouri form that you can get online, but basically you're checking off what you would and wouldn't want in terms of care. And many times people just want to be comfortable in their dying hours. It is really hard to contemplate. I get that. Just because I want to live, you want to live, we want to live, we want to be part of this earth. And anyway, so the living will healthcare directive is part of those documents while you're living. And then finally, there is a HIPAA authorization, which would allow whoever it is you've authorized to be able to get documents from the doctors on your behalf. And, when we go to the doctor, we're always signing the HIPAA waiver saying, it's okay to give, my husband, my kid, the documents. And this would allow the person you designate to be able to get those documents. It seems like less of an issue with the advent of these healthcare portals like MyChart or whatever it might be, where the doctors are all able to kind of communicate within that system, even if you're like at St. Luke's or at KU. But it's part of what I offer, the HIPAA authorization as well. So the other part of when you are doing estate planning and when we are preparing those documents, and I can prepare them, we'll go over, you'll know exactly what's in them. But part of this process is talking to your loved ones about what you want to see happen. And, what would be the scenario if, you were brain dead or had terminal cancer and couldn't speak for yourself? What would you want to see happen? And, those conversations, although they are so hard to have, are so useful for your loved ones later on. The other thing you want to discuss with your loved ones and the people that you've named in the documents are to tell them where the documents are. Everyone that is named a power of attorney in your documents needs to know where you keep those documents. And, we give a binder. It would be something that you could place in a safe, but that would be noticeable. And, so that's good, but you still have to have those conversations. I read this wonderful book called On Being Mortal by Antui Grande, and it is a book. He is a doctor, New York Times writer, and he documents the last part. He documents his whole dad's whole life, and his dad, I want to say, was also a doctor, but anyway, just kind of his journey. His dad was sick at the end, but they were constantly talking about what was the level of care that the doctors should give to his dad. Just incredibly useful information. It's a beautiful book. You should definitely read it. I totally love it. Okay, so that is documents while you're living. That's one set of estate planning. Now we're going to talk about the documents for when you pass away. And, I think in the United States, in popular culture, movies, television shows, there's sort of this really like big concentration of the will and the reading of the will. And I in the spring, when the show Succession was on, somebody passed away, and there was lots of discussion on Reddit and other forums about, is there going to be a reading of the will, and what does the will say? And the will is important, but really what is of equal importance, if not more, is the trust. And there's not really reading of wills anymore. I mean, it's kind of a movie trope, I suppose. But so I'm going to tell you a little bit about what I would do. And this, like I'm saying, my ideal client is me. And so we have created a trust. My husband and I have a trust together. And basically what we say in that trust is that our belongings go to each other when we die. He gets what I have, I get what he has or what we have together. And then when the last of us passes away, it's to be divided equally among our 3 children. God willing. I mean, I don't even know what we would have after, and who knows, because my time may be up tomorrow. But that is how it's spelled out in the trust. And basically, the trust gives the trustee, the person that is going to administer your trust, the ability to do that outside of the court system. It's a private document. It's not made public. It doesn't need to be published, but the trust gives the ability for the trustee, so whoever that might be, your trusted person, and then also a backup and maybe a backup to them, to be able to marshal your assets, and whether that's selling a home or whether that is getting the assets from the retirement account, from the bank accounts. That is what they're able to do, and then split the money, in our case, 3 ways. And so that is what a trust does. I mean, I'm sure there's a lot more of there are trusts that are within trust that are within trust. I was talking to another lawyer at Christmas time, and she was talking about how she had 8 trusts inside of one trust. And this was for an extremely wealthy client, and, was setting it up that way. That's not my target market, but there are more complicated trusts. And we're going to talk about another trust in just a second. But the one I'm talking about is a revocable trust. And so there's some terminology that goes along with trust. I would be Me and my husband would be the grantor of the trust. We are the person setting up the trust. We are also the trustees. We have a trustee to be named in the documents for after we both pass away, but we are still the trustees. And the deal about a revocable trust is that you can go in and change anything at any time. We're still in charge of everything. We are in charge of the money. We are in charge of the house. We have not given up any control of that. Another part of a trust that is important and that my office will help you complete is to put your assets in the trust, because many times people would draw up these wills and trust and do the whole estate plan. But if you don't fund the trust, it doesn't mean anything. It didn't effectuate anything. When I do estate planning with people that have a house, we do one beneficiary deed as part of the package. If there's more than one house, then we charge that. But we use a beneficiary deed to put the name of the trust, put the name of the trust on the deed. And we do that in Jackson County by beneficiary deeds. Okay, so and then the last term that we would use in the trust situation is our beneficiaries and who the beneficiaries would be. And so in our case, it would be our 3 kids. So those are the beneficiaries of our trust. We would also be going into our bank accounts. We would be going into our retirement accounts. And now how we do it is so on my account, on my retirement account, my husband is the beneficiary. Our trust is the secondary beneficiary. On his retirement account, I am the beneficiary and the trust is the secondary beneficiary. And so it would make it easy if I'm still living, but if I'm not living, then it gets dumped into the trust. All right. So what about a will? Well, a will is very useful for people, families, like the Smith family that have young kids and they want to name a guardian. And I gotta say, it was somewhat. We really went back and forth when we had young kids about who we would want to take care of them. I mean, what a terrible situation to contemplate. That we would not be around to parent our children. But, those decisions might have to be made. And wouldn't you be the one that wants to make them rather than a court or having your parents fighting your in-laws or your, best friend saying, she always said my daughter was going to go to me. I'm like thinking of terms of endearment right now. But all right. So that is a primary use of a will. When I'm talking about my target market, I'm so embarrassed I had Thai food today. I'm burping. I hope you don't hear this. Is that what the will does is, hey, there might be some assets out there that didn't get titled in the trust. I want you to take whatever those assets are and put them in the trust. And more recently, I'm helping someone administer their trust, and they are in a situation where there is a piece of property that was not in the trust. And so the will is giving them the ability to put it in the trust and thereby being able to sell it. But we are having to go through probate to do that. We are not, it's something where it wasn't planned, but we still want to be able to pick up whatever assets might be out there that didn't get into the trust and put them in the trust. Okay, so those are kind of that's like the nuts and bolts of estate planning, the documents while you're living and the documents when you pass away. What I think is one of the most important parts of estate planning is, after the documents are drawn and, you said, yes, that's what my wishes are. It's spelled out how I want it to be, is helping you get your assets into the trust and also giving a clear picture so that your beneficiaries or whoever that may be, the trustee that is serving for you on your trust after you've passed away, very clear instructions on what they're supposed to do. And like I said, I haven't been in this game very long in terms of, I've been a lawyer for what I feel like is forever, but in estate planning for about a year, less than a year. And that is, giving somebody, I don't see that. I feel like I don't see that enough, where the lawyers are very clear with instructions and what the wishes are and how to go about executing that. And that's what I want to give to my clients. I think it's important. So, what the situation is after I've drawn up the trust, the whole estate planning documents. And, we had an interview where you talked about who you are. And basically there's 1, 2, 3 people that you want to decide for your medical care, 1, 2, 3 people that you want to decide on your finances. And then 1, 2, or 1, 2, 3 for trustee, and 1, 2, 1, 2, 3 for the personal representative of the will. And many, many times those people are the same people across the board. But it's also might be a situation where you feel like somebody, one kid is not going to let you suffer, and one kid, would be more stoic about the decisions. But of course, you've talked about these decisions with these people, so they should know no matter what. But like I said, generally, same person, your trusted person across the board. And then, of course, your beneficiaries. Who are they? So I get all that information. We draw up the documents. I send to you PDF versions of those documents along with a video that I do that's reviewing the documents. So you can go through and review all the documents. You can listen to the video and you can go through on the highlights. And then if you say, yep, that's what I want, we arrange a signing ceremony, and we can do that at my office. We can do that at your office. We make this easy for you. At the signing ceremony, I'm a notary. The person that works for me is a Kansas notary. I'm a Missouri notary. He's a Kansas notary. So we can notarize those documents. Some of the documents require witnesses. So we'll have witnesses present. I love it at my home office. I have my neighbors come over and they witness things, and they get a kick out of it. And I'm so grateful to them. And, but sometimes we go to somebody's office, and it's very easy to have a notary or have witnesses at an office that you can pull people in. And the witnesses are basically just saying, I saw you sign that. So we get the documents finished. I take the documents with me, or I keep them. We scan everything, put it on a thumb drive, put it in a binder, and present to you the binder. So that is what so that is my process. And then you're done. It has instructions in the binder. It talks about, what each document means. There's a letter to you. There's a letter to your beneficiaries and your trustee of what to do. So that is sort of my process of what I do. Now, blended families might need a special kind of trust called a Q-tip trust, which would basically split it up depending on the assets and who was still alive. And sorry, I'm kind of have now been talking for 40 minutes, and so starting to run out of steam here. Okay, I told you I was going to talk about irrevocable trust, and here I'm going to talk about it. An irrevocable trust can sometimes protect your money if it ends up that your loved one they need to end up in a nursing home. And this isn't talking about assisted living. This is talking about a nursing home. Something bad has happened, and your loved one needs to go to a nursing home. An irrevocable trust, if executed correctly, can sometimes protect those assets. And that's why, but just like it sounds, as opposed to the revocable trust that I've been talking about. An irrevocable trust, you're giving someone else. Someone else is the trustee, not you, not the person that is making the trust. You are the grantee, you are the person making the trust, but that somebody else is the trustee. We know that nursing homes can be extremely expensive, and they're Anyway, I've got some opinions about nursing homes, but it is a solution, irrevocable trust. Now, there wouldn't be many situations where my ideal client would be doing an irrevocable trust because it's just not that time of life, but it might be something you're starting to think about when you're hitting your 60s, 70s is when you would start talking about that. Okay, this is my final topic about probate court. And I am new to this. I have my first probate case. It's coming along. It's somebody that died without a will, but that did have assets. And so we needed to present that to the probate court to ask the court to distribute the assets, basically. And the people at probate court are so nice and such, they're obviously dealing with people that are in somewhat of a shitty situation. I'm having lunch tomorrow with somebody that does probate litigation. And so, of course, this might be a situation where there's no will. And so there are people maybe fighting about that. They might be doing something where they're asking the judge to appoint them as a conservator to a trust, a conservator to an estate, and that somebody disagrees. So then there's fighting. But that is basically, if you die without your documents and you have assets, it is likely that to get title to those assets, that your loved ones will have to go to probate court. And there are lawyers that do this that are so good at it. I'm getting better at it. But many times I refer those out, because especially if it's probate litigation, because that's not what I'm doing at this point in time. So probate court, your family could end up there. All right. I think that is all I have to say. I can't believe how busy this library is. I mean, people are coming in and out, and maybe they want to get away because it's a cool place to sit. But the Red Bridge Library, I'm in this great big room. Nobody signed up for my estate planning seminar, but you did. You're here. Thank you. I'm doing these the third Wednesday of every month for the rest of 2023. I bet there'll be at least one person here next time. I did mainly all my free social media, my Facebook page. I put it out on Google Business. I put it out on Nextdoor. So I might put some paid advertising to it. I might send something out to my email list. But I love this topic. I think it's so important. And of course, yes, I'm selling something. So of course, I think it's important. I'm selling this service, this legal service. So if you have questions, please call my office and set up an appointment. We have weekend and nighttime appointments. I know people are working. They can't necessarily take off time to go see a lawyer. If you want to do it over Zoom or over Google Meet, we can do that. If you want to meet in person, we can do that too. All right. Thank you so much for watching. Have a wonderful day. Bye-bye.